The defense was arguing two main points for continuance today. The first one is that kind of the same argument that they've had in the past. There's way too much discovery. They said 68 terabytes of discovery in this case. They don't feel like they can put up an effective defense based off of the amount of discovery that's out there. The second is that information has been leaked to Dateline that was previously sealed under the gag order. Defense feels like that could taint the jury pool. Can you kind of walk us through what the defense is thinking with these two arguments and what maybe they're hoping to kind of see come from all of this?
Yeah. I think there's really two primary things, especially when it comes to that first argument about the mountains of data that have been disclosed by the prosecution in this case. That's an issue that defense has already raised before. But when you're looking at a case from an appellate perspective, usually what the court will do is they'll look and see when the issues came up and whether those issues were preserved for an appeal. Preserving something for an appeal means you're objecting early and often. And so I think half of this is defense making another argument that, look, Judge, we are getting close to the day of trial and we still haven't unpacked all this data yet, right? Thousands upon thousands of pages, millions of pages even, right? Of data in these terabytes of information that's been disclosed. So again, the first part of that is just saying we still need more time to unpack all this. And the second part of it is just making sure they're renewing that objection for the purpose of preserving that for an appeal down the line. The second part here, as far as the Dateline leak, that's kind of a argument that cuts both ways, right? Because you publish something, right, and it goes out there into the world, and of course that's going to be picked up if it's interesting, right? If it's new information, everybody's going to be talking about it, right? But there's still a sect of the community that probably hasn't been exposed to that Dateline information yet. And the longer we wait, the more likely that's going to kind of diffuse through the rest of the community. The more people are going to hear that information. And so while the defense has a great argument that this is all new, it's all stuff that the community should not be hearing right now, it's stuff that's prejudicial to their case. At the same time, the longer they wait, the more likely it is that people will hear about that, either through the Dateline special itself, by talking to their friends and family who have watched the Dateline special. So it's kind of a tricky argument, because while it does cut for defense, it also cuts for the state to push this case forward before more people watch the special, right? That's a tough one.
This is kind of an
excuse me.
This might be a silly question, but with something like that, the new information that came out, the judge and the prosecutor, everybody seems to agree, yeah, this is going to come out at trial. It just wasn't supposed to come out now. What makes something more prejudicial to hear it today versus during trial?
So that's a good question. It's tricky because, as you've seen through these motions in limine that defense and the state have both filed, when we're in trial, we're trying to not only control the facts that come out, but the way those facts come out, right? Because a fact can come out one way that's pretty inane, it doesn't really mean a lot. Or if it's come out and they put a lot of emphasis on that fact, it can really change the way the jury sees it. And so I think the really concerning thing from defense's perspective is that way that these facts came out in the Dateline special, right? They come out and they're sensationalized and they're conclusory about meaning that, you know, this was their client's fault, that their client did this. That's putting a spin on the facts to some extent. So while these facts might all be facts that come out during the trial, defense wants to be able to have some control over the way in which they're introduced and have some control over the conclusory, argumentative way that they're produced in the trial.
They don't want the dramatic music playing behind it. And
yeah, because that's all way worse for them. Right? If somebody goes into a case, one of the things about being a juror is being able to tell the judge, the defense, the state, tell everybody else in that room, I have not made up my mind about this case, and I truly believe that he is innocent as I sit here today. Right? Those are the things you have to be able to say as a juror to be able to make it onto a panel, is that you believe in this idea of innocent until proven guilty. That presumption of innocence attaches and is maintained by the defendant throughout the entire process until the jury is asked at the very end of evidence to make a determination. Right? At that point,
Gotcha.
that's when they're allowed to decide whether he's innocent or guilty. And when you have all this evidence coming out into the community with a spin on it to some extent, right? Whether it's spun that way on purpose or not, it's outside the control of the defense and the state. And so it's prejudicial.
Gotcha. That makes sense. You had kind of touched on this already a little bit, but the defense has made the same argument while trying to get a continuance in the past of the amount of discovery that's out there. The judge didn't buy it last time. He said, I believe his reasoning, and the state kind of brought this up again, but I believe the judge said, we'll address this before trial, but I want to see you come and say exactly what it is you feel like you're missing from this, and what is your plan to go and get it. You're not going to get just a forever continuance. I didn't see that from the defense today, as far as any, here's the plan or here's what we're missing. Do you feel like what kind of...
I think if I remember right, their original response to the court in that question was, Judge, we don't know what we're missing because we don't have any way of looking at all this data and making sure we can compartmentalize and categorize all of it moving forward into trial, right? Judge, and I believe that they brought this up right at the close of discovery originally, saying that there's just too much here. We don't know what we're missing. We don't know what we need that they have. There could be things in here that are very important for us to be able to present as theories of innocence or information that shows our client didn't do it, but we do not have the time or the manpower to be able to pick through this haystack to find the needles that we need. So the judge kind of told them, well, you need to tell me exactly what color the needle is, where the needle's located. And defense's response has been, Judge, it's a haystack. I know what needle if I see it, but I can't tell you what needle might be in there.
Gotcha.
And I think that's still where we're at with this case. So I think defense is doing a really good job of preserving that objection. And, you know, if this comes down later on that there was some information in that discovery that was not found by defense before this case is wrapped up and been able to be presented by them in their case, then that could very well lead to an appellate issue, right? And they're doing a great job of preserving that issue now so that if that does happen later on, it can come back on appeal.
Gotcha. Let's see. The state seem to be saying that the defense is trying to have their cake and eat it too when it comes to the start of trial. They pointed to a specific motion where the state was trying to get their own psychological evaluation of Kohberger in the wake of his autism diagnosis.
Mm-hmm.
At the time, the defense said, no, we're about to go to trial. We don't have time for that. So then we've moved on now from that issue, and now they seem to be flipping around saying, oh my gosh, trial's about to start. We don't have enough time to finish all these things. And so the state seemed to be saying, wait a minute, you guys are trying to have it both ways. Is that just gamesmanship by the defense, or is that what kind of stands out to you from that?
So I think that there were two main objections, and that issue is a really tricky one because Idaho Code, I think it's 18207, says that mental health is not a defense to any crime. And if you present something under 18207, basically talking about how someone's mental health or diagnosis affects if you present something under that, talking about someone's diagnosis and wanting to introduce it to the jury, that same statute allows the other side to go get an independent evaluation done. And so what defense was objecting to was kind of two things. One, they were saying this is not an 18207 issue, right? This is not the type of issue that allows the state to come talk to my client and see if if their expert has a difference of opinion as to what the diagnosis is. So that was the first part of their objection. Second part of their objection is the state wanted to go not only have psychological testing done, but personality assessment testing done. Mm-hmm. Defense's response was, we didn't do that. We didn't do any sort of personality assessment on our client, And having you come talk to him when we haven't done that on our end is a violation of his Fifth Amendment right to remain silent. And the judge actually agreed with that argument from the defense, declined to allow the state to go do a personality assessment on Kohberger, but did allow them some time to go in and do an 18207 assessment as far as getting their own expert in to see whether they agree or disagree with this autism diagnosis.
I see.
So while defense did make some arguments as far as timeline goes, I think that their main thrust of their arguments was this doesn't actually count under 207 to allow you access to our client.
Gotcha.
As a defense attorney, like, you never want your client in the hands of the state. You don't ever want your client to be compelled to talk to someone who's a representative of basically law enforcement in a case. And so what they were trying to do, I believe, with that objection is to protect their client's right to remain silent as the case is pending.
That makes sense. The state, their main rebuttal seemed to be the defense is trying to get what they said was a quote-unquote perpetual continuance by using the Dateline episode and then the docuseries and then the James Patterson novel that we spoke about earlier as a reason why we won't be able to effectively seat a jury. But the problem is as the state says, is that every time something new comes out, will we then continue at that point too? And so at what point do we say, yeah, stuff is going to come out and we just have to go find we have to go seat a jury? The one thing, just to tag on to that, the Idaho Supreme Court says that, let's see, the Idaho Supreme Court says that information that comes out even on the day of jury selection is not necessarily reason that you won't be able to seat an impartial jury. What stands out to you from that argument?
So I think to really understand the thrust of both sides, you kind of have to look at where both sides are trying to go. And I think primarily the state here, their main goal is not only to have this person convicted of murder, but also sentenced to death, right? And defense's main goal here is to try and see if they could, if they're swinging for the fences, they're trying to see if they can completely walk Mr. Kohberger on these charges and say he didn't do it. If they're settling for a okay result, if they're settling for an okay result, that's where he does get convicted of murder, but he does not get the death penalty. And so the further out defense can push this case, really what they're trying to do is save his life, right? And the longer they can make this take, the longer he gets to stay alive if they lose. So defense will always push for continuance. They will always push for more time because that means their client gets to stay alive longer if they lose. State will always try to push this forward, right? Because they have momentum. They have the victims' families who want justice and they want it now. They have media attention. They have people that are interested in the case, that want the case continued forward and pushed forward. And so generally in a case like this, we'll always see the state trying to push the case forward, and we'll always see defense. Sorry, I'm losing my voice a little bit. We'll always see the state trying to push the case forward, and we'll always see defense trying to ask for more time. So you're 100% right. Any time that defense has an opportunity to ask for more time, they will do that because that gives them more time to mitigate. It gives them more time to let the community cool down about the case so that there's less pressure for the jury to pick a death penalty sentence. And it gives them more time to put together more information about who Kohberger was on a positive side to try and mitigate this death penalty sentence, possibly.
Do you think that there's any actual weight? I mean, hearing what you're saying, this is a natural argument for the defense in this situation. But do you think there's any actual weight on the side of that the information could have been so damaging that was released in that Dateline episode that there could be an argument made to say we should wait?
Yeah, I mean, I think that both of the arguments defense are making are good faith arguments. They're good reasons for giving them more time, right? They have a great defense team. They've got a bunch of attorneys. They've got jury consultants and experts on this case. They've done a lot of their own investigation and research. But really what they're asking the judge for is more time to make sure they can do this as well as they possibly can. And I think that they can say that, good faith, right? 68 63 terabytes of
68.
information is an incredible amount of information. Even if you have a couple years to go through it, that doesn't necessarily always give you time to parse it and synthesize it and bring it all to bear on the case you want it to. And so while they do have a lot of good resources, I don't think this motion is frivolous in any way. That's why I think defense is doing a good job in resolving, or not necessarily resolving, but they're doing a good job in keeping their arguments in place for the purpose of an appeal,
Gotcha.
right? As far as the Dateline stuff goes, that really cuts both ways again, because yeah, it's bad that it came out. It's bad that the community is going to hear it. But if I hear those facts today, and then I'm called to come to a jury 2 years later, I'm going to remember, right, to some extent, what I heard 2 years ago. I might not be as upset about it 2 years later, but I'm still going to remember it. So it's kind of a double-edged sword as to whether that Dateline episode is going to get them any actual traction in this motion.
Makes sense. What, just to kind of wrap it up, and then if Dakota has any questions, but what are kind of your final thoughts after this hearing? What should we expect between now and jury selection?
I think between now and jury selection, we're going to possibly see some more motion in limine practice. I'd imagine that'll be pretty sparse. I think they've briefed most of the main issues. But between now and then, I think we're just waiting to see what those jury questionnaires come back at. Right? I think those are going out sometime soon. I think the jury's going to get picked as far as selected who's going to be in the pool. And then moving forward, the court's just going to be getting ready for the great volume of people that are going to be coming down there.